Welcome to Secura Law Experience. I'm Luis Elizalde, founder of Secura Law. I'm here with
Stephanie de las Millar
and Eduardo Beauregard.
Welcome to a new episode. Today it's gonna be a episode that we already talked about it. It's about promissory contract, but we're gonna do like an update of the oldest or an older episode, just to clarify if we have questions or any case that you may think that you can speak about it.
I can start.
Will be good.
Yeah, actually, just yesterday I had a phone call with some clients, a video call by Zoom. Mm-hmm. And one of the things that popped up at first was the question if we were going to draft the contract in English for them.
Mm-hmm.
And
just English?
Is that, no, I mean, they were asking, since we speak Spanish in Mexico, if the contract was going to be in English for them to fully understand. And I explained to them that the way we do it is, yes, our laws state that all binding contracts have to be in Spanish, but as a courtesy, we make a 2-column contract, one in Spanish and one in English, so they can read it side by side and understand what the contents of the contract is.
You know, about that thing that you just said, something that has to be, from my point of view, and also for more clear contract, is that in both sides, for example, in Spanish you have the clauses and you have the clause 1. Mm-hmm. In English, the other side, exactly in the same, has to match, because I saw that some attorneys say, I already do the Spanish version, because English is courtesy, I put it there. And they don't care about matching. And it's a nightmare for the clients, because they are buying, they are investing here. So one of the best things that we can do, of course, as an attorney, is look all the legal issues, mm-hmm, on all the legal aspects. But to give that is an extra that we can give to the clients, so they can fully understand the contract and they can compare. And still, right now, with all the technology, they can put it in ChatGPT or any other
automatically
AI.
Translated, yeah.
Exactly. And look at it. Hey, it's the same thing that it's saying in English to Spanish, and they will find that it's the same, and it's going to be, I think it's going to be easier for the AI to do that. So
yeah,
I think that's good. It's something good that as soon as you, as an investor, as a buyer, you see a contract that match the English with Spanish, you know that I'm pretty sure that it's going to be a good contract. No 100%. We're going to speak about,
but that gives you more trust.
Exactly.
I mean, if I were to go, I don't know, to the United Arab Emirates, whatever, that they have another language and law system. If I see a contract, exactly. If I see a contract and let's say the clause in Spanish translated to me is like this big, and I see over the other language and it's a full page, I say, there's something you're not telling me, right? What is it?
Exactly.
Something you don't want me to know, that creates distrust towards that thing. So It's very important for the contract to be like this, side by side, so it gives you more trust, like, hey, looks the same. I don't read the other language, but I know that in the contents, it may say the same because it's the same length.
And makes sense.
Mm-hmm.
Yeah, totally agree.
Logical.
So that could be one point. As you said, courtesy. English is a courtesy. The Spanish is going to be prevail always, mm-hmm, because we're in Mexico.
Basically.
Any other point that you may think?
All the things that came out on that meeting was that they asked me if they could reshape the contract to put clauses that are more familiar to their law system. That means basically I told them yes and no. Mm. First of all, we have to follow the customs and the law of Mexico because the deal is made in Mexico. However, we can adjust some clauses to relate them more to what you're used to and feel comfortable, as long as they don't go against our laws and our clauses. So the point here is to create the trust for the investor to feel safe to send money here, and purchase property. And we do whatever it takes as long as we're not contravening our laws and clauses. That's the main point there.
And I mean, they told you about what kind of clauses they were in mind?
For example, one of the things that come up the most is regarding the who's gonna inherit the rights to the contract. We have that here, but it's not really that common. Usually contracts don't have that, and if they have it, it's because somebody requested it. So those kind of things, I told them, if the contract does not have that, yes, we can include it. It's part of your normal contract there, but here it's not against the law, but it's very rare for a developer to put it there. So
but
we can
for
add
example,
that.
to put the person that will inherit the rights of the contract has to be an individual person or a corporation, but cannot be, for example, a family trust.
Oh, no.
No? Because
No.
that exactly, as you said, it will be incompatible with the jurisdiction of Mexico because we don't have that legal figure.
Yes. And
But
I
it
think
still
that's-
doesn't work. You know, it's not common, but for example, we already have that with another client that he passed away and he put her daughter thinking that in case of death, but he already paid, if he already pay all the full price, they're gonna submit or they're gonna put the title at the name of the daughter. But what happened if they are in a pre-sale and they're making payments? That happened, and it was, I think they pay only 50% of the purchase price. He passed away, and the daughter say, "Hey, I never knew about this property. I
don't
never
want
knew.
it."
I don't want it. Just give me the money back." And the idea of the developer is, because you are in the contract, you have to pay the other 50%. And that could not happen. Why? Because she didn't sign the contract. She didn't.
Bind herself.
Exactly. So, no makes sense if the other person never know or didn't sign the contract.
Yeah.
You know? So, to say the truth, I don't think that clause.
But I mean, in the legal Mexico legal system, you have to reject. If you inherit a lot of things from a person that passed away, you have to reject the ones that you don't want because you don't want to absorb the obligations that come along with the
Inheritance, yeah.
Inheritance
in a
exactly.
will. But in a contract.
in our system.
But in this case,
But
it
I don't know
protects-
what it will work in, for example, in the States.
It will
No,
protect
but with
her
a will.
against the developer wanting to resell the property. If she really wants it, she could say, "Hey, I'm in the contract as a beneficiary of the rights, and I want to use them." And if she doesn't want to, she'll say, "I don't want these rights.
But I'm
Let's
talking
cancel it
more
out and give me back the money that."
more related to
parent
the
paid.
will because yes, of course, she's not part of the contract.
Exactly.
It's more like what will happen regarding the will.
If there is a will.
If there is a will,
But
of
if
course,
it's a-
and if what it says according to every law of every country of the world.
But in Mexico, doesn't apply in a contract.
She'll have to sign
Exactly. If
as
they
a,
want to,
as a owner of the rights in case of passing away.
just to be sure that she's aware or he's aware or the one that they want to put. If something happened to me, okay, but I will put the condition. If the property is 100% pay, the title is gonna be at my name. If something happened to the one that is or the principal beneficiary, if something happened. If the condition, if it's already paid. If not already paid, I want the money back and the seller can sell the property to someone else. We cancel this contract and that's it. I will put that conditions. You know, because sometimes, or if they are aware of that and they decide, okay, if he pass away or her pass away and didn't pay, okay, I can pay it, no problem. But has to be his or her signature.
I think the point here is to give them a better leverage to deal with this with the developer. Because if
Exactly.
they don't, the developer would say just that, doesn't matter. The person that bought passed away, so that money's mine, and who are you? Right? If the contract, if the clause is in place, then you have a better leverage to go and negotiate with them. Hey, I'm the beneficiary. I don't want it. Give me back my money. Or yes, I do want it. So let's sign a new agreement stating that we've already paid the 50%. There's the wire transactions. There's the connection between me and that person because he's my father. Whatever, right?
But the condition has to be there, not just the paragraph. Okay, if something happened to me, go directly to my son, daughter, whatever. Wife,
Yeah, exactly.
spouse, husband, whatever. But the thing is that has to be conditions. If not, I don't think, because we already happened, that experience, the reason, the Corallo experience.
Yeah, those are the kind of things that are not normal, but that they could help.
But it's good
Right.
that we speak about that.
Yes.
Can't think of another one.
But just like, as I said, it's a refresh. So it could be a good idea just to explain that how is a contract written here in Mexico, how is the structure, or what is the structure of a contract, or more important, the promissory contract, because I'm pretty sure that they say promissory note, and for us, promissory note is a pagaré. That is almost the same, The promissory contract
It's binding.
it's kind of the same. But at the end, in the promissory contract, by law, by the civil code of, let's say, Quintana Roo, because we are in the state of Quintana Roo, established that the promissory contract is only an action to do in the future. And the money, there has not to be money, it has to be deposits. Of course, by custom, we establish the promissory contract to formalize a trust. We establish like the purchase price as payment in that, as a normal promissory
As
sell and buy
deposits.
contract. So there is little difference, but this is more by custom that doesn't affect totally. But we have to be more specific with the client so they can understand the structure of the contract. If you want to explain that, what is the structure of the promissory contract, will be good.
Yes. I mean, the first part obviously are the parties, the buyer and seller.
The introduction, let's call it.
Exactly.
Right?
Exactly.
And then the statements to know where, who they are, basically.
And how they're entering that contract, right?
The faculties that they have, what are
Who are
really
they?
important.
Their ID number, their tax ID. If they have
Corporation.
if they have the, what would you call it in English? The capabilities of entering into a contract, either if it's by a
Faculties.
corporation with their powers of attorney, or if they are not mentally ill, if they are a person.
They know what they are doing.
Exactly, and they know that what they are doing, and they
Some
can bind
developers.
themselves.
No. No, I'm joking.
Then we have like the
Or maybe not.
actual clauses.
They have the legal faculties, but maybe not the mental faculties.
Disclaimer.
we never know. Well, but at least they are saying that on their oath to saying the truth.
Exactly.
But it's really important.
That's very important because sometimes they establish, the promissory seller established this or says this.
On their
but this
oath.
is very important. On the road to
On
say
their
the truth.
oath.
If you don't find that in the contract that you're reviewing or you're saying or you have in your hands, something is funny there. So that's very important. Good
Yes.
one.
Or there is a not good lawyer drafting the contract.
Yeah, because that opens you the possibility to have a
They
better
forget.
case at the court
Yeah, they
against
forget.
that, because they
Sure.
are saying that they are expressing themselves on their oath, and that gives you a better chance to go against them because they were blatantly lying to your face, basically.
Yeah. And you know what? I saw another day a contract from a developer that it was kind of course, more directly on benefit of the developer. But in the statement of the buyer, they established that because of the buyer has a legal representative that reviewed the contract, there is nothing to claim about this contract. And I say, okay, but if I'm asking, because we request some changes in the clauses, and they said, no, the contract has to be like that. I said, so take out in the statement that the legal representative and there is no more claim, because we are asking for some change to be an equal contract, and you are saying not. But you are putting this on behalf of the buyer. No, makes sense. So no, don't do that. So
Yeah.
little words make a huge difference, and it's not like
Devils in the details.
Exactly, exactly. So please consider always to hire an attorney to review the contract. Maybe you already have a lot of experience buying 10, 12 houses in Quintana Roo or in Mexico, but always it's a good idea to have a lawyer to review, an attorney to review the contract, just in case. You never know, and you're going to make an investment of 300,000, 200,000, 10,000, 100,000 or 50,000, and you're going to pay an attorney maybe $1,000 for your investment. I think makes sense.
Totally, totally. And you know that you have this legal assistance to explain you what it has to be in the contract and what it's not really necessary to protect your investment. So
Yeah, I mean, some of the things that I tell clients and brokers is that the sooner we get involved in the transaction, the better. Of course, you can sign an offer without legal assistance. But if you want to sign a contract, it is not recommended to enter into that agreement without having a lawyer reviewing all that stuff.
yes.
So that's the pivotal step between good decisions and bad decisions.
Totally.
So it's just a matter of people pondering what they really are looking for, right? For something to move fast and may have problems in the future, or to move slow and really make sure that everything will go as planned.
Exactly.
You never know. So that's why statements, it has to be declared by both parties, that both parties come in good faith and under oath to say the truth. So you can know that they are actually providing the information that it's true, and that you can claim afterwards if something happens.
And if it's
in
not,
a
you
trial.
can have a better case at the courthouse.
Exactly.
And I think one of the important things now is the final part of the contract. What about the signatures?
No, wait. But we were...
In the
Stephanie
statements.
said... Exactly. Stephanie said introduction, then the statement, then the clauses. And how the clauses are structured. Of course, the object of the contract, the most important, or between the most important, why is the reason of that contract, then purchase price, and then penalties. Let's say in general, because that's the clauses that you have to be aware.
The more important are object, purchase price, payment schedule, responsibilities and obligations of both parties, penalties, and exit mechanism. Something that I see most people miss is that last part. And for me, that's the most important one. You need to establish an exit mechanism for both parties to be as clear as possible. Because when you bind yourself into a contract, you need to know how to get out. Because to be realistic, anything could happen. And just to sign something with a good faith, let's say, yes, this is going to have no issue, I'm going to be happy. We all like to live like that, but you have to prepare for the worst. So you need to have that exit mechanism there.
Totally agree with you. Sometimes they only have like the penalties, but it's from one side and not the other. It has to be very clear, very clear.
Yes. And the legal consequences of
Exiting.
Exiting, exactly.
Yeah.
Because, I mean, it has to be some way, but also it has to be legal consequences for both parties. So, and also kind of situations that are not in both parties' hands. For example, another pandemic. I hope that it's not. But I mean, situations that are due more to external factors or to the authorities, that doesn't mean that the contract won't be valid, but that maybe will need an extension, and both parties have to be agree on and have maybe an amendment agreement establishing the new terms and everything. But this possibility that there are some things that are not in your hands, not in the seller hands, and that you have to create a plan B. So you have also not an exit, but an alternative to not be stressed about, okay, I'm not able to travel on April the 30th that we agreed to sign the deed. Okay, then I communicate with time to the other party and we establish a new closing date. That kind of things that doesn't bring stress situations to both parties where there is no stress. They still want to do the transaction, but they need to change something.
You know what? I'm just thinking what you're saying could be a good idea, and just thinking out loud and in this moment to establish a clause that sometimes it's not the lawyers, it's not the seller, it's not the buyers. Sometimes the authorities, because when you are acquiring a property, of course you need then to deliver the property free of any lien, encumbrances, or any debt. But in order to get that documents, right now the authorities are like, it's like a nightmare right now.
Yeah.
To get all that documents.
Unpredictable.
Yeah, exactly.
That
so
for lawyers it's a nightmare.
exactly. So I think it could be a good idea because, of course, we have the clause that says a major force is not going to be considered as delay. However, it could be a good idea just to be a little more specific that any delay regarding the answer about the authorities could be the permit, could be the pre-closing document.
The cadastral certificate is the most common.
The appraisal.
The appraisal right now. So I think could be good idea to add that to the contracts that is not fault of any of the parties, could be seller buyer. And of course, as you said, to explain to the buyer and seller, hey, this is happening in the contract. It's already established that it's not going to consider a delay. So let's establish a new date for the closing until we get this. Because sometimes the buyer or the seller say, you didn't get this document, so I'm going to sue you. Dude, it's something that we cannot control. It's not in the hand of the seller, it's not in the hand of the buyer. Still not in the hand of the attorneys.
Yes. Exactly.
But if you pay the expedite fee, no, that doesn't work also. So I think could be a good idea just to add it. Not gonna be a harm to anyone, and I think it's gonna be clear for everybody. So just thinking.
Yes, no, totally. We have it already, but I think we have to be more specific.
Exactly.
And to explain to the parties in a clearly way how we will handle these kind of things, so they feel always safe. That it's our main intention, that you feel safe in every step of the way. And then the clause of the execution of the contract.
The exiting, because I've seen very, very commonly the part that they establish penalties, but are penalties, for example, a partial non-compliance. They delayed the delivery, or the buyer delays the payment, so therefore they have to pay X amount of percentage by day or a fixed rate.
That is great.
And they bypass completely the penalty for actual termination. And sometimes they do it backwards. They only have a penalty for actual termination, but they don't have penalties for partial non-compliance.
Most of the developers don't want to.
So that's part of the exit mechanism. You need to know how much of the purchase price or whatever the penalty is going to be set for actual exiting. And enforcing it. I want out, and therefore I don't want to have to calculate with, hey, you delayed X amount of days and then you have to pay. That's a nightmare.
If you go, if you put your feet in the shoes of the developer, I understand the idea what they are doing that, of course, but it could not be clear, or it cannot be better for the business. I'm just thinking. I don't know how the market works.
I know where you are going, and I agree.
to be very clear with the clients, hey, if something happened, first, this development is gonna be built until we got all the funds, until we sell 50% or 60% of the unit. That kind of thing that could be really, really nice to explain to the clients. Because I don't know, the developer now, yeah, we have all the money, we have all the experience, we are the best. And in 3 months later, they don't even start, you know? And I know developers that now they are retired, that they said from the beginning, everything to the client, everything. If something happened with the carpenter in the kitchen of the unit, number 3, they call to all the buyers. Hey, this happened. That we have a delay of 15 days because in the unit 3 the carpenter make a mistake and we are gonna
or
fix
run away.
it. Yeah, or run away with the money, but we are fixing it. And all the clients understand that
Communication.
the communication. But he was always they were really clear with the clients, and all the development that they did, they were perfect. The maintenance fee, I never hear any problem with the maintenance fee. But now looks like the developer tried to take advantage of the
Make money out of it.
Yeah,
But you know what? One of the things that I see that's the most detrimental towards developers is that they don't put enough attention to the post-sale service. If they would just create a good team of post-sale, they will solve all their issues because they will be in constant communication with the buyer.
That is the key, constant communication.
The post sales area of the developers are very neglected, in my opinion.
I think because at the beginning, I'm just thinking, of course, and in my opinion, at the beginning they start building, or they have an idea, they have the concept, they have the blueprints, they have everything done. They start selling, and suddenly, I don't know, to sell one property or 2 properties, they say, the buyers, they say, hey, I want, instead of the kitchen from this side, I want a kitchen 30 centimeters from here, and this washer, and this, and the developer in areas to sell the unit say, okay, of course.
Yeah, that's a big mistake.
So every time that they make changes, all the blueprints, they have the pipes, the sewage system, I don't know how to say it, but they have
the
everything
electricity and hydraulic installations
already done.
Blueprints.
But that 30 centimeters make a huge difference.
Everything.
And okay, for that unit, maybe they do it great, but because they move it, the other unit is gonna be a mess, and the unit in the other side, because they change this cable, you know. So I will say, be true with your vision as a developer.
Yeah.
Of course, I'm not in their foot, and
learn when to say no.
Exactly.
I can't. You know, we have a client, a developer, that had a delay of 1 year and didn't have to rescind any contract or pay any compensation. Why? Because we advised, okay, you have to be super close to your clients. Every time that something happens, communicate to them. It's not bad to say, I'm sorry, I made a mistake, because everyone makes mistakes. The thing is to come clean and to explain and to say why. And they always understood. And he never had to pay a compensation, a penalty, anything. Obviously, were some crises between the clients that were not fully understanding everything. But having a good legal counsel, and really, I mean, we might bring him some time so he can give his testimony about how was developing, being with having a legal consultation during the entire project until the very end.
That is a good question. I mean, that's a good part. We have brokers, we've had clients, now we need a developer.
Yes, I mean, that one, I think he was satisfied with our service.
And to let us know their experience on their side.
Yes.
Because
We
it's
have
very
it.
different.
Yeah, totally agree. We have the experience. We have the market with all the brokers that we know, the clients, you know.
Yeah.
It's great.
But I mean, this is a free advice. Developers, communicate with your clients, but you not use an intermediary post service sales that they don't know what they are doing sometimes, and they
don't do a
promise
good job.
sometimes things that they don't know if they can
Or are
have or
impossible,
not.
just to
To
take their clients away from them because they're on top of them all the time. So they will say
Exactly.
whatever to keep them happy.
Exactly.
But it's
and
a
then you
timing-
have to figure it out.
It's a ticking time bomb. At some point, it's going to explode.
always, always.
Yeah.
So that it's a
And-
free.
And the other thing about the contract is the actual execution. You don't have to be here. You can do it. You can sign it through DocuSign. You can also sign it physically and send it by FedEx. There's a lot of ways to solve that
I prefer
matter.
DocuSign. Always,
Yes.
always. And there is a lot. Not all attorneys always attorney. How do you say? Old school attorneys.
school.
School.
Everything in writing. Yeah, everything in writing. Yes, and I can say that not my signature. That's the truth. The client can say it's not my signature, or the developer can say it's not my signature. But with a DocuSign, with all the IP, everything, how can you deny that is your cell phone, that is your IP, that is your internet, that is there is a real electronic trail?
And timestamp.
Exactly, and it's crazy, and it's better in a courthouse. It's better. You cannot deny that. There is no way to say I didn't sign or I didn't know, because you receive it in your cell phone or you receive it in your email, or it's almost impossible to deny that contract was signed by you. I didn't have, and they hacked my email. Really? You know, and your email was
Why you
in your
didn't report
house.
it.
They hacked you in your house, in your office,
Yeah.
because you know exactly location. It's crazy. So I prefer
Definitely.
DocuSign. To say the truth,
Yes.
it's better
So do I.
DocuSign.
And it's easier for people that are abroad, which most investors are, right?
And it's still, you know, if you are here and you don't want to go to the notary to an office and stay there for an hour, 2 hours, you open it, you review it, and that's it. You know, it's
Yeah.
it's a tool that we have to use.
Makes
And I
our
see.
lives easier.
Yes, and safer. I mean, it's safer.
That's the word. That's the word. Safer. Safer. Legally speaking, it's safe, and it's safer. Sorry, because in a document that you sign by hand, you can say it's not my signature, and you
And
don't
it's very
have time
common.
stamp. You don't have exactly when you sign it. You don't have the place where you sign it. You don't have anything.
Yeah.
And they say it's better if you sign really by hand.
Yeah.
Come on, we have the technology. They can look at your face right
Just
now.
use it.
You know.
Yes. So
Exactly.
Yes, and it's
I'm gonna
important.
get my bye.
It's important that in the contract it is stated that both parties, I mean,
of
from
course.
the Mexican legal point of view, that the contract is stated that both parties agree to sign in electronically.
Yes. Totally. Because of the producer said that is enough. We have to say goodbye. I think it was a good episode. We spoke about our cases, about the promissory contract. You like it? Subscribe. Yeah.
Yeah.
Take care. Bye.
Have a nice
Bye.
one.